Okay, what up, peeps? Um, I thought I paused the first video, but I actually stopped it, started another one. Anyway, this video is about presumptions. I was speaking with a guy earlier about presumptions. I'm gonna post this thing right here about the presumptions of the court. There are many presumptions that they operate using in the court that you have to rebut. I'm not gonna go through all of them. Hell, I probably don't even know all of the presumptions. But I did a video on the 12 presumptions of court. If you look in you Google that, do that in your Google search, you'll actually find where it says 12 presumptions of court. You'll actually be able to find it. A video. It's an article that goes over 12 of those presumptions. Those 12 presumptions. I'm sure there are more presumptions than just 12, but those are major points in that article. So just look that up and use that accordingly. You know, one presumption is they're treating you as a legal fiction. You never register the name. They're treating you as the name in all caps. The all caps name is a business entity. John Doe is a business entity. That name's supposed to be registered in order to create a separation between you and that name. You need to register that name. You need to create. You need to put that. You need to place yourself in the right position to use that name, to be the authorized representative of that name and be recognized as such. And if you don't do such, they're going to treat you as the name itself. It's just like when someone calls you and you have say you have a phone bill, a cell phone bill by Verizon, you know, and you're behind on your bill, or just say your bill is due. Okay. And then you get a phone call. One of the representatives call your phone. And he's like, I need to speak with John Doe. And this is Melissa calling for Verizon. I'd like to speak with John Doe. Melissa never told you her whole name because she's not the one doing business with you. She's not the one that's doing business with you. Is actually she's the authorized representative for Verizon. She's acting on Verizon's behalf. Verizon is the business entity. Just like you're supposed to be when they ask for John Doe is a business entity. So the name in upper lowercase name, that name should be the name, the authorized representative for the name in all capitalized all capitalized letters. That way, when if you're talking to someone over the phone and say, this is say it sounds kind of fun if you're doing it over the phone and saying, just say if I say, I'm John, calling on behalf of John Doe. You know what I'm saying? It technically would be right if the name's registered, because the name John Doe is actually once you register that name, it's a business entity. And the name in upper lowercase is the name that's the authorized representative of that name, the grantor, the beneficiary of that name. You also and when you register the name, you also here in Georgia, we put it in the newspaper for 2 weeks. Okay, making a claim on the name itself, stating the nature of the business and your position concerning that business with respect to that business. And I was stating that I'm the executor over the estate, the name in all capitalized letters. I will state that in there as well. Put that in there, have that added in the newspaper as well, all in one article. You're stating your claim in the article, in the newspaper, in all capital, about the all caps name, about the estate itself, your position as the executor, you being the beneficiary for that name. You create and using when you're speaking of yourself, you're putting your name in upper lowercase in its proper form. Okay. Some people they like to say their name should be in all small letters, and I've seen nothing where you're supposed to be doing that. That's something that people have made up. They haven't found any legal documents, any legal sources that says that your name should be in all small letters. Okay, proper form is where they'll recognize you as the what they call the private person. Okay, they don't want to see you as a. They don't. Living men and women don't exist in the commercial world. Okay, when you're operating with paperwork and all that different stuff, you know when you're dealing with the commercial world, they're gonna call you a person regardless if you're in the commercial world. Living men and women will not. They don't see you as a living man or living woman when you're dealing with commercial activity. Okay, so you will not find where they're calling you a living man or woman. They're going to call you a person. But there, you have to look up the word person so you'll know that there are many types of person when they call that. When they call you that, there are many different types of person. There's an artificial person, there's a natural person. Okay? And you're referred to as a natural person. Okay? Now, better stay on topic. With the presumption, you're rebutting the presumption that any judge is acting as that whoever that judge in that case is acting as executive over your state. Okay, this is once you complete the process. Like say here in Georgia, I take a certified copy of their registration. Okay, and I attach it to say if I'm on child support or something like that. Footnote, I'm not on child support. Okay, never been on child support. I beat my case. Okay. But say if you own child support, you're trying to get off child support, and you want to use a Rule 60B rule as a way to try to get off. Okay, you want to and you register the name, and you want to file a motion in there because Rule 60B requires you to file a motion to do that. Okay, say Rule 60B it speaks about how to be relieved from a judgment or order. Okay, and it says by motion. You have to do it using a motion. Now, so that's to kind of kill those. People talking about, don't use emotion because you're asking the courts for something. Why not? You ask for every goddamn thing else. And when you have evidence attached to it, they can't deny you. But you attach evidence to your motion, you should have evidence attached to your motion anyway, not just a regular motion. That's why motions get denied, because you have nothing to support it. Okay, back on topic. And you say you're rebutting the presumption with your registration of trade name. You're rebutting the presumption, for one, that you're operating as a fiction. You're rebutting the presumption of death, because the only way someone can should supposed to be administering your estate is when you're dead. Okay, so you're killing that presumption. You're rebutting that presumption as well. You're also the attorney is also acting as, or the social worker attorney, whoever the opposing party is, they're acting as a beneficiary over your estate, over that name. You're taking control of that name as well. You're rebutting that presumption. Okay. They're also presume that name is pretty much abandoned because you never claimed that name. That name in all capitalized letters is an abandoned name. The name upper lowercase is the name that your father and mother gave you, but they created an entity for you to conduct business with that you never actually registered to claim any type of power over that name. So registering that name, gives you control over that name as well. So before you do that, they're gonna try to operate. As long as you're acting as that name, they're gonna presume control over you because you're acting as that name. And so when you take control over that name and you're using your real name, your name that your father and mother gave you, that upper lowercase name, and all that's in the registration statement and it's filed in their records, and you take a certified copy of that, you're rebutting all those presumptions that they're trying to do in court. They're trying to attach a body attachment to a legal fiction. And that's exactly what they're doing when they're locking y'all in child support cases. They create a body attachment to the legal fiction. It's just like creating a body attachment for Walmart, or for Target or Kmart, all these different business entities, you create a body attachment to it. Notice when Melissa calls and she calls on behalf of Verizon, you can't create a body attachment with Melissa and Verizon unless Melissa was to injure you some type of way, but she's only doing her job. As long as she stays within the policy, she's immune. She's not going to be held accountable for nothing. Okay, so the entity itself has to be held accountable for its own whatever contract it's in. Okay, but you have to make sure that you are you are in your right position when it comes to that name. Take control of the name. If you register the name, you got to know understand why you're registering the name and why you're filing it. Don't just follow people. Don't just follow anybody saying I'm registering the name and not knowing why you're doing it. Don't do anything that not even just registering the name. Anything you choose to do, make sure you know why you're doing it. Okay. Yeah. So I'm explaining to you what with the presumption. What about presumptions concerning that name? They're operating under presumptions. Okay. Also in my motion, I would also throw in there about the Parental Rights and Responsibilities Act. They have to also have evidence that you're unfit, that you've caused some type of physical harm, serious physical harm to the child or children, or you make a decision that could be detriment to the child's safety or their life, be a threat to their life. So if they don't have evidence of that, then the government officials don't have authority to get involved. They can't intervene on your right to direct the upbringing of your children. That's what the Parental Rights and Responsibilities Act of 1995 says. Go back and read that. I can't stress that enough. I've talked about it in every single one of my videos damn near. So if you haven't read that and went and studied it front and back, then you actually half-assing it right now on my channel. You really need to go do that. Okay, study that out, because that's actually key. It's very key, and you can raise that act says that you can actually raise an objection. You can raise it says you can raise a violation of that act in any proceeding, any court proceeding, any court proceeding concerning your children. So you need to be raising it. Child support is the state intervening in your right, your parental right, your fundamental right to direct the upbringing of your children without governmental interference. They don't have authority to do that unless they have proof that you have caused some type of serious physical harm to your child, or you've put your child's life in danger. It's just like when somebody leave their child in a hot ass car and it's 100 degrees, it's 100 degrees outside, and leave the child in there by themselves. And, they have no business, and say a little 5-year-old, 4-year-old, they got no business in the car by themselves anyway. Even though it don't even matter if it's good temperature. They shouldn't be in the car by themselves anyway, not at that age. But either way, you're placing the child's life in danger when you leave them in there like that. So the government has the right they have merit to interfere in your right, in your fundamental rights to govern the upbringing of your children, because you're endangering that child's life. But if they don't have these types of evidence to provide, and you don't raise any objection to it, they're going to continue. They're going to move on forward with more presumptions, as if you actually did exactly whatever baby mama or baby daddy, in some cases, very few cases, but in some cases, whatever they said you did or whatever, you have to raise an objection. You have to raise a violation of that right. So the government can't get involved. Government officials, they can't get involved. And I will make sure I will mention them by name in my motion, because now you're creating a public record in your motion. You're filing into your court case. Anything you file in your court case, it becomes a public record. Okay. So, because somebody can always go and get something like that and have affidavit. Say you attach an affidavit to it, it's sworn under penalty of perjury to the facts of what's going on. I will have 2 witnesses sign my affidavit if I do one. And, you attach that to your motion, whatever evidence you have that you want to attach to your motion. You want to make sure you address those whatever evidence you have attached to your motion. You make sure that you address those exhibits and say and explain why they're relevant to the case. Okay. And that's how you'll get your success with a motion. Okay. Now, that's pretty much, I think I went a little further than just talking about, presumptions, but that's exactly what, it rebuts those presumptions that they operate in court when you do those things. Evidence rebuts presumptions. You have to be willing to provide evidence to prove what you're saying. And let me talk real quickly about evidence. Evidence, if you're taking if it's paperwork, some type of documentation, it needs to be if it's an affidavit, it must be notarized. And I would in every case, this is just me. If you have witnesses to prove to the facts, you want to have them to sign your affidavit as well, swearing under penalty of perjury to the facts, because there's a maxim of law that says every word should be established by 2 or more witnesses. Okay, that's also Bible scripture. They do swear on the Bible for a reason. There are many laws that are written in the Bible that they use in court. Okay, so you want to make sure that, if you use an affidavit, if you have witnesses, make sure you have witnesses swear on the penalty of perjury that this is true on this document, and then it's even stronger because your words are being established. Okay, the more evidence, the more the stronger your case. Okay, um, if you have, say, something you went and got a copy of from like say if it's a police report, or you got, something from the sheriff department or the county clerk's office, you get a copy of something, make sure you get it certified, get a certified copy. That's when they stamp their stamp and their seal on it, and it's signed. It has a wedding signature by their deputy clerk signing off, confirming that this is a certified copy of the original. So you want to make sure that it's certified. If it's, if it's an affidavit, it's a wet ink signature. It's not something that's printed off of some computer and it's a computerized signature. It needs to be wet ink signature. Okay. And the notary's stamp needs to be wet ink. Okay. Wet ink signature, wet ink, everything. Okay. So, it's a difference if you type up an affidavit, with all the verbiage, and then you have the witnesses sign before a notary, and the notary sign it and date it and put their stamp on it. You can do that too, because those are still wedding signatures. But it needs to be original or certified. Okay, if you're going to use it as admissible evidence, that's what they have to be, to attach it to your motion or whatever you're going to attach it to. That's thought I just kind of throw it out there. I think that's it. I don't want to kind of just ramble on and say some more, whatever. I can just talk forever about this stuff, really. I think I'm done for now, though. I'll catch y'all in the next video, y'all. I guess I name this video Rebutting Presumptions. All right. Emeralds signing out.